Morning,
you don't
everyone.
have court today. You was released back on the 15th. You don't have court today. You're going to be reset for the notice, and you'll get a notice from the divisional judge on when you'll come back to court. You can go upstairs to the third floor. I mean, not the third floor, the first floor in this building, room J150. Make sure they have your correct address and email, but that you don't have court today. Are you supposed to report to your pre-trial officer? Because I don't show anything. So why did you thought you had court today?
All right, good morning, everyone. We were servicing someone in the courtroom, so I apologize, and to make sure that we got them to the right place. All right, if everyone is ready, do I see my assistant solicitors on the line?
We're here.
Okay, good morning, good morning, good morning. There we go. See a few more faces. All right, good morning, everyone. I am Judge Regina Mincy, and this is the state all-purpose calendar in the State Court of Fulton County for today, which is Thursday, January the 27th, 2022. I want to remind everyone that this proceeding is being recorded and live streamed on YouTube or through the internet in this Zoom format, which means that the public can view this proceeding. I want to also remind you that you have a right to remain silent. Anything that you state about the facts and occurrences regarding anything involving your case can and will be used against you. So be very cautious when speaking. Defer to your attorney and let them speak for you and represent you well as they are able to do. Also want to let you know that you do have a right to an attorney, and most of you already are aware of who your attorneys are. They will be on the screen, and we'll make sure that you obviously have representation for today as well. And these, Ms. Champion, just go back to for the notice, right?
Yes,
so there's no reset date. Okay. All right, we will get started. Are we starting in courtroom 2 or are we starting at the south?
South.
South.
24, Mr. Patterson.
Okay, 24.
Good morning, Your Honor. That's my case.
Good
Ian
morning,
Purr.
Mr. Purr. Yes, how are you?
I'm doing very well, thank you.
Good. Okay.
Your Honor, Mr. Patterson, I learned yesterday, has been assigned to Judge Edlin. He was a bind over from Atlanta Municipal Court. I represented him over there.
Okay.
He was being held down in, I believe it was Upson County, one of those counties down there in Middle Georgia, on a unrelated matter. And
Okay.
we could never get them to produce him up at City of Atlanta. And finally, Ms. Carey, the solicitor over there, and I just elected to get the case over here to state court, since we couldn't resolve it short of a jury trial anyway. And so, of course, I did not get any notice when the case was actually accused a little bit over 2 years after the date of the arrest, by the way.
Mhm.
And neither did the address where he lived, which was currently occupied by his mom. So apparently he got in bench warrant status for that reason. I just want to get him out on a signature bond today, either an entry of appearance and certain pretrial motions. But guess what? State Court of Fulton County has apparently not enabled e-filing for criminal cases. Fancy that. And so I guess I'll just have to do it the old-fashioned way and take a drive downtown or use the mail.
Ms. Champion, aren't they doing e-filing?
Yes, is he trying to e-file entry? What?
Right, yeah, he stated that he couldn't. I thought they were live with their e-filing
Yes,
a couple of years ago.
yes, ma'am, as far as I know.
As far as, and I'm speaking to my clerk, as far as we know, you were on Tyler and looking at that, and it wouldn't allow you to e-file, or did you need to sign
It
up?
wouldn't. I've used it for civil filings over there. Maybe I
Right.
got the number.
Your connection froze, Mr. Furr. I think we've lost him. Okay, let's see if he comes back to us. Mr. Furr? Who's hosting? Is it Mr. Jordan?
Yes, ma'am.
Mr. Jordan, do you see that we lost him?
He's not showing in the waiting room, Judge, so he may be still trying to log back in.
Still trying to log back in. Let's see, he went off the screen. I hate, but they're able to e-file, correct? Mr. Jordan?
The e-file is available. The attorneys can file via e-file. Some of
thought
the things are
so.
accepted automatically, and some things have to be accepted by the clerk's office.
Oh, but his entry and things like that, those can be e-file, correct?
Yes, but someone still has to go in and accept it and add him to the case. So he won't be automatically added to the case like a civil.
Okay,
e-file
when
where
you
the attorney
file
can add
something,
themselves to
right.
the case, right? So one of the
Mhm.
clerks have to actually go in and add his name to the case.
Yeah, but I thought, for the most purposes, he could certainly get into the system and e-file it.
Just
Well-
he was stating that he couldn't even.
Yeah, he was stating he couldn't even get in, and the state court wasn't accepting e-file. I don't know about that. That's not true, I don't believe. Well, we'll wait till he comes back. Deputy, in the south, who else? Do you have anyone else there? Looks like, is that your only?
You can go to the courtroom too, Your Honor.
Okay, well, let's do that. I don't want to lag too much. I thought he would be able to get right back in. But as soon as he does, we'll come back. Let's hold on Mr. Patterson and go to courtroom 2.
We got position number 39, Mr. Joseph Younes.
Okay. All right, you're Joseph Younes. This
Yes.
is case number 22 CR 0000175F. You're charged with 1 count of theft of services with the offense date of January the 11th, 2022. And I see Mr. Finley.
Yes, Your Honor.
Whose case is this from the state?
Me, Your Honor, Attorney Mecca Anderson.
Okay, Attorney Anderson, go ahead, you may proceed.
Thank you, Your Honor. What we are looking for here. Oh, you know what, Your Honor? Give me 1 second, please. I don't have my correct case pulled up. I need 1 moment.
I know, that's okay, we're
Off to a little
kind of
slow start this
switching
morning.
around here.
Yeah. Bear with me.
Uh-huh.
It's Kayla, I'm sorry, Kayla.
Oh, there he is.
I knew
Your
he
Honor,
would.
didn't mean to leave you.
I understand it wasn't personal. We were trying to start the next case, and so maybe that was good. We got you back in so we can kind of go back to,
Yes, Your Honor. These are both my cases, but I do need a second on Yunez. I'm having a little
Okay.
bit of issue with that particular case. I apologize.
okay, are you prepared? Can we go back to Mr. Patterson?
Can do Patterson, yes.
Okay, all right, we'll come back. South, can you hear me?
Thank you.
Okay, sorry
Yeah.
about that. There we go. All right. Can you hear me, Mr. Patterson? All right, let me start back over a little bit, Mr. Farr, and at least call this case 21 CR 007-058D. And this is 1 count of DUI less safe and 1 count of failure to maintain lane or improper lane change, both with the offense date of October 25th, 2019. While you were gone, I did confirm with our clerk that you can e-file in these cases. You just have to wait for the clerk to accept them once you submit them. And then you'll get your envelope number, but he said that you could. There's some things you'll be required to bring down, but your entry and those initial motions, you should be able to e-file those. And then you may have to call to make sure they've added you to the case, where in the civil cases, once you do a pleading, you automatically get added. You know, for future notice, but here you may have to double check that. But you should be able to e-file your entry and some of those motions.
I think I must have left the D off of the case number.
Oh,
Oh,
okay,
yeah,
then that
that-
could be, it. Okay, gotcha.
Pro-
Okay.
Probably nothing more complicated than that.
Okay, sounds good. Let me let the state go first, and I've gotten a little bit from you. And we finally got Mr. Patterson here. And this is ASG Anderson's case. So I'm gonna let her present first and then we'll come back to you. Okay, Mr. Farr?
Yes, ma'am.
All right, go ahead,
Thank you,
Ms.
Your Honor.
Anderson.
On this case, the state requests 12 months to serve 30 days. I do need assistance from the court on knowing the current time served by this defendant. We're looking for the balance to be probated, ADET, $500 fine, 800 hours of community service.
80 or 800?
80, $500 fine and 80 hours of community service.
Okay,
Please forgive me if I misspoke. 1 VIP random, random testing and ignition interlock with 12 months probation, and this with 12 months probation, Your Honor. Yes. Do you need to hear the facts of this case?
you can give me a little brief update.
Sure. On 10/25/2019, the defendant was driving on 7585 near 166 East, and he failed to maintain his lane, crossed over the median, and collided with another car. The impact caused the defendant's car to spin out multiple times on the interstate. The defendant tried to leave the scene, but couldn't due to the damage that he did to his own vehicle. This defendant, Your Honor, also has 15 total cycles. Mostly they are drug charges and failure to appear charges, with a 2018 conviction for a probation violation. And so for those reasons, Your Honor, that's why the state is making the aforementioned request.
Okay,
Your Honor, we would dispute the facts of the case as alleged. This is a DUI marijuana allegation. And the circumstances of the case are, after our legislature had legalized the possession and use of hemp, denatured hemp cigarettes, my client was in possession of about half a package of unsmoked hemp cigarettes in the vehicle with him when he was stopped by the officers. He went through a recitation of what he had and what he didn't have. and the officer was unfamiliar with the change in the law with regard to hemp. And I think that the communications between them deteriorated, and at that point, he was just going to jail. He attended court every time that he could up until he was brought in on that case down in Upson County and could not attend. I attended for him. I must have gone down to City of Atlanta on this case 7, possibly 8 different times before the closure of the courts got everything discombobulated at City of Atlanta. I still represent him on this case. I believe that he has good and sufficient defenses on this case. He's never shown any willingness or intention not to appear in this matter, and he's made provision for counsel to do so to guide him through that process. I think he's on a case of this nature a perfect candidate for a bond, and a signature bond and a reasonable amount should be offered to him. He was given bond on the RICO case down there in Upson County. And if he can make a bond on a RICO case, I think he ought to be able to make a bond on a hemp cigarette DUI case.
Okay. Give me a little bit more background on Mr. Patterson, age, job, things of that nature.
Mr. Patterson is, I'm going to let him speak as to how old he is. I don't have the old file in front of me. I just have yesterday's notes.
All right.
I,
How old
I,
are you? Okay.
I believe he's in his 30s, late 30s, maybe 40, in that range. He's always worked for a living. He's supported himself. He's helped to support other members of his family. He's been timely with the payments that he made toward my retention in the case, and he had a stable address the whole time before he was taken down to Upson County and removed from us.
Okay. How old are you, Mr. Patterson?
32, man.
All right. What type of work do you do?
Like construction. And,
Construction?
yes, ma'am. I have a clothing line.
I didn't hear you.
Yes, ma'am. And I have a clothing line.
Okay. And a clothing line, self-employed.
Yes, ma'am. So I can
And you are turning down the offer from the state. Is that correct, Mr. Farr?
Yes, ma'am, absolutely.
Okay.
By the way, I never did get discovery over in City of Atlanta, so I want to see some of the stuff that the state's talking about, and obviously I'll have the opportunity to discuss the case further with Ms. Dufford, who's the solicitor with permanent assignment to it in Judge Edwin's courtroom.
Your Honor, because this was a bind over from the City of Atlanta, we don't have any of the bond information that the state wanted to give the bond information. We don't have any information.
Okay. Ms. Anderson, can you give me the bond information, because we don't have the bind over file before us?
You know, Your Honor, in my notes, I have here that I don't have bond information, and to ask the court what is the current bond. I also don't have current jail time information right now, Your Honor.
Correct.
The information hasn't made it to us, I'm thinking.
Mr. Furr, the same issues I guess you have getting the documentation we have as well. Do you have that information by chance?
As to what the amount of his bond originally was,
Mm-hmm.
I don't know, because he had made bond at City of Atlanta when he first came to see me.
Right.
And so, I mean, it wasn't anything that was germane at that point to my inquiry. We didn't anticipate that they were going to try to bring him as a peripheral player to some big shots RICO case down in Middle Georgia. I mean, we just didn't have any reason to anticipate any of those things.
Correct.
That got him sidetracked from the regular course of his life activities.
Right.
We didn't expect that they would hold him without bond for so long in an attempt to pressure him to give testimony against people that he didn't even know, much less associate with. And so he just got himself in an awful fix because of somebody that he shook hands with once upon a time.
Right,
And it's been
Your Honor,
downhill since.
okay, yes. Ms.
I'm not saying jail information. I'm not saying bond information, only the criminal history. 2014 possession of a weapon in an attempt to commit a felony, marijuana charges, sometime around that time frame as well. That's the only information I have.
Is pretrial on with me?
Judge.
Good morning, how are you?
Good, how are you?
Good. How many cycles do you have for Mr. Patterson?
I have 15 cycles. The 2014 drug charges out of Clayton County, they were first offender. There were 2, they were sealed in 2019 and 2021. And then there's a misdemeanor possession of marijuana less than an ounce in 2008 and 2018. 3 probation violations within the past 10 years. Nothing further.
Okay. Mr. Fur, if you don't mind, if your client can answer, does he remember or what his bond was down with the city? You have any clue? Does he remember it all?
I'm fine with him answering that question, Judge, if he can recall, because I surely don't.
Yeah. Do you recall, Mr. Patterson?
I'll put it this way, whatever it was, he performed within his ability to do so completely. He did what a lot of fellows don't do and went out and hired private counsel to walk with him through a case that he thought was unjustly brought against him. And it's a misdemeanor at worst. At worst, it's a misdemeanor. We're not talking about a John Dillinger here. We're talking about, smoking hemp cigarettes that the officer thought was actual marijuana.
Right.
That's about as bad as it gets. Maybe, a lane violation or whatever. If that's the case, he's not charged with hit and run or leaving the scene, irrespective of the colloquy we heard earlier.
And Mr. Patterson, are you from Georgia? Connections here in the Atlanta area?
From Atlanta, yes, ma'am.
Did you graduate from high school?
I just finished 11th grade.
11th grade?
Yes, ma'am.
His mom, Vicky Patterson, lives here. I believe it's down East Point, Forest Park, down in that part of town. And she's been in continuous communication with me during the whole interregnum of this case.
All right. And is that where you're going to be living, Mr. Patterson?
Yes, ma'am, with my mother, yes, ma'am.
Okay, and where does she live?
I think she had just moved, I think it's McDonough.
In McDonough?
Yes.
She was down around East Point. I know she had some serious health problems last year, so she must have moved in response to that. But I talked to her on the phone. She calls me at least once every couple of months, at least.
Okay. All right.
Your
Anything
Honor,
else, Ms. Anderson? Yes.
I did find some additional facts. The hemp cigarettes that Attorney Fur is referring to did also have marijuana logos on the pack. I also wanted to clarify that the state's recommendation is that the counts can run concurrent on both counts as well. And that's the only new information I have, Your Honor, besides what you've already heard from pretrial.
Okay. All right. And again, Mr. Fur, you're turning down the plea offer, correct?
At this point, absolutely. I think I've got a constitutional duty to investigate the case further. And frankly, the presence or absence of a pictorial portrayal of a marijuana leaf has less than little to do with culpability in the matter.
All right. What I'm going to do is on the DUI, I'm going to give a $1,000 surety bond. And on the improper lane change, $500 surety bond. So that'll be a total of $1,500. And that will be a surety bond. I'm going to state that again, Mr. Patterson, I'm assuming for the most part that your driver's license are already suspended and that you don't possess a current license. So there will be no driving unless you have a valid driver's license. Otherwise, you have to do ride shares and get people to drive you around if you get out on bond. And usually what I tell people is you can drive if you have a valid license only to work, medical care, or to see your attorney. So very limited driving if you end up getting your license back or have it. I'm also going to say that there should be no drugs, alcohol, or weapons while on bond, except for prescription drugs that are given to you via a medical prescription. And so no other drugs or substances while you're on bond. Okay. So that's going to be my ruling for today.
Thank you, Your Honor.
Oh, and I'm sorry, Mr. Furr, can you email the bond order to April.champion?
Hold on.
Okay,
April.
you can give it Miss Champion, or if you want to put it in the chat as well.
Okay, I'll put it.
She's gonna put it in the chat. Are you able to see the chat, Mr. Furr? But she can read it real quick. It's April.
It's empty right now, but I will need a copy of it in order to email it to anybody.
Okay, no, he has to create.
No, you have to create it because you're private counsel.
Oh, okay. And to whom, and I get it to Miss Champion for your signature?
Yes, yeah, April.champion
At FultonCountyGA.gov.
at FultonCountyGA.gov.
Do you have a particular form you prefer, or may I use one that comports with the law, but might not be the one that y'all see every day?
Oh, as long as it comports with the law, that's fine.
And Your Honor, the state is ready on UNES whenever you are.
Okay.
I think Mr. Patterson's
Yes,
trying to
Mr.
speak.
Patterson, do you have a question?
No, I was wondering, could I say anything? 'Cause I didn't get to say nothing.
I need to be very careful.
Yeah,
The state's listening to you, and it may be something better suited for your attorney, unless
that's
it's
just-
something about your bond.
And that's his lawyer's advice too.
Need to be careful. Is it something about your bond?
No, it's about the case.
No, this is not that type of hearing. This is just for bond. And I caution you talking about the facts because you may say something that is not in your best interest to say that could be held against you later. Your case is not over. This is just a bond hearing. So I think you should be cautious and defer to your attorney and speak to him later about the factual basis. That will be heard by the division judge. Okay?
That's right.
And so making sure too, as Mr. Patterson, obviously, has he been arraigned on this case?
No, he has not been arraigned. I was going to go ahead and file my pre-arraignment motions.
Okay.
And
Okay,
there's a particular motion. I think the state was a little late in accusing the case.
okay,
So not really giving anything away. Ms. Dufford and I agreed to disagree about the applicability of a special motion.
do you want to, are you going to file a waiver of arraignment with your entry of appearance, or do we need to do it today?
I will file one. I'll just go ahead and add that
Okay.
filing since I've got to take the trouble to prepare a bond order.
Okay, so we'll get a bond order, entry of appearance, and waiver of arraignment. Those will be the three documents that Ms. Champion will be waiting on.
Would the court be willing to reconsider signature versus surety on that? It's about the only thing it's going to do is take a little money out of his mama's pocket, because he's obviously been in a position where he couldn't earn anything for a while.
Your Honor,
Yes, Ms. Anderson.
I believe you've ruled on this.
You know, he, and the totality of the circumstances, and we've got a little bit of history here, Mr. Furr, and the 15 cycles, I consider that contacts to the community, things of that nature. With the surety bond, this is a pretty low one. And if he was able to bond out previously, he obviously can go through the bonding company on that. And I want to make sure that he will return. And just listening to all of the circumstances, I think that the 1,500 surety bond is pretty fair at this point.
All right. Just
All
want to
right,
get it
thank
one more try, Judge. Didn't want to push my luck. Well, I wanted to push it just a little bit, if you understand.
I do understand you. You've been great counsel for Mr. Patterson. So good luck to you, Mr. Patterson.
Thank you, Judge.
Thank you.
That
All right.
concludes our business then. I'll go ahead and work on that order and submit it to Ms. Campion by email.
Right. So we've got three things: a waiver of arraignment, the entry of appearance, and the bond order. If you could send her all three of those, that would be excellent.
Great.
Okay. Thank you. Appreciate
Thank you
your
very much,
time.
Judge.
All right. Have a good one. All right. So
Y'all,
we're gonna.
you ready for us? Position
Yes.
number 39, Mr. Yunus, Joseph Yunus.
All right. Position 39.
Hello.
Hi. Yes, this is case number 22 CR 0000175F. You're being charged, Mr. Yunez, with one count of theft of services. There is an offer there, and I see your attorney, Mr. Finley. Pre-trial, do you have anything?
Yes, Your Honor, one moment.
Okay.
8 cycles. Let's see. 2019 theft by shoplifting misdemeanor conviction. FTA from 2019. Burglary from 2020. It appears he's maybe on probation. He was sentenced February 12th of last year. 1 year confinement, 1 year probation on a burglary in the second degree. I have a case number as well.
Right. Is this going to be a plea, Ms. Anderson and Mr. Finley?
Yes, Your Honor.
It is. I guess I should have asked that at first, so I apologize. All right, State, you may go ahead and proceed and tell me what the plea is.
We have 12 months to serve, 15 days credit for 15 days balance probated, and no further contact, and stay away.
All right. And no further contact with the victim.
The location, Your Honor, really just to stay away.
So you do want the no further violent contact with the victim, or you do not? I see that on the disposition here on the
It
calendar.
does say that, Your Honor, but Attorney Fielding, this is not a violent case, right? This is the burglary case. This is the theft by threat to food service case.
Yes, that is correct. Yeah, it's the theft of
There's no
service.
violence
No,
here, Your
okay,
Honor. He just didn't pay for his food. That's all.
okay,
That's what
gotcha. All right.
Does she have to stay away?
But he needs to stay away from that location, is that correct?
That's right. That's
Can you
right.
give
It's
me the
MF
address?
MF Sushi Restaurant, 299 North Highland Avenue, Northeast in Atlanta.
And that was 299?
Yes, Your Honor, 299 North Highland.
All right, Mr. Finley, is that your understanding of the offer, the offer?
Yes, that is, Your Honor. And as previously stated, this is a theft of service charge involving a bill at a restaurant, as was said. Mr. Yunus is or was a college student and has hopes of re-enrolling in college. A young man has his whole life in front of him. We are okay with the customer service, but we are asking, because he is a young man, hasn't been working in a while, that his probation fees be waived. And once he does complete that 40 hours of community service, that the condition, the balance is suspended or not reporting.
And I think Ms. Anderson did say that. Well, she said balance probated. Can he come off probation once he's completed the terms? Ms. Anderson?
We leave that up to your discretion, Your Honor, considering, what you heard from pretrial.
Okay. Where was he in college, Mr. Finley? You
I
know?
believe it was an online college, Your Honor. I do not remember what the name was, Judge.
What?
Mr. Yunus, what was the college you stated?
I went to Bergen Community College. It's in Paramus, New Jersey.
Your Honor, I think there was one bond condition that we did not read, which is a theft prevention class.
Oh, I see it on here. Okay. Theft prevention class. All right. And then the 40 hours of community service, correct?
Correct.
And how old is Mr. Yunus?
He's 24 years old, Judge.
All right, Mr. Yunus, can you raise your right hand for me? You affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And I've already informed you earlier, if you heard me on my calendar, you do have put your hand down. You can put your hand down. You have the right to remain silent, that anything that you say about the facts and occurrences of your case can and will be used against you at a later date. So govern yourself accordingly and defer to your attorney. And you see your attorney here, Mr. Finley, is that correct?
Yes.
Okay. All right. At this time, I have heard the state's recommendation and I am willing to accept their recommendation, but I need to go through the plea statement with you. Mr. Finley, do you have the plea paperwork together? Or are you going to get that over to Ms. Champion?
Yes, I'll get that over to Ms. Champion after court, Your Honor.
Okay. All right.
Miss? So what is happening right now?
So I'm getting ready to ask you some questions if you are going to plead guilty. Is that correct?
No, I was actually not trying to plead guilty. I was just trying to change my what's it called? I was trying to change it so I could get a signature bond.
Mr. Yunus, you remember we spoke about the different options yesterday, and I went over the questions with you about the different options of whether we could argue bond today. And I went over the deal with.
Well, I'm not trying to plead guilty. I'm trying to plead innocent. Oh man.
You all need to be in a breakout room possibly to discuss that
Yes.
before we go forward, Mr. Finley?
Yes, Your Honor. Could I please?
Yeah, Mr. Jordan, can you place them in a breakout room, please, so they can talk? Because of course, I will not take a plea at this moment.
Yes, Your Honor.
Judge, who did you do the breakout room for?
Mr. Finley,
And Mr.
I guess in courtroom 2 with that defendant, but I'm afraid if we do that, we're not going to be able to move forward with the other cases, will we?
Mr. Finley.
Your Honor,
Oh,
Mr.
Mr.
Finley,
Finley needs to
Mr. Finley,
call.
you can call extension 22392. Call extension 22392. You go to that chair, pick up the phone and call. Your Honor, we're gonna move on to position number 37, Mr.
Yes.
Polaris White.
Okay.
Hold on, Judge. I'm the beginning of the calendar. Mr. Finley is the end of the calendar.
I got you, Ms. Helen.
So if I'm calling from my personal cell phone, what would that phone number be? It would just be.
It's gonna be 404-642-2392.
So 404-642.
612.
Okay,
2392.
got it. Thank you.
Okay. Ms. Helen, do you have 15? That's the only one I have.
Oh, yes, I have 15.
Okay, we'll be bringing up Mr. Anthony Jones, position number 15.
All right, thank you, Ms. Helen.
Thank you, Judge.
Your
All
Honor,
right.
negotiated plea.
It is, okay. This is case number 21 CR 004272C. Are you Anthony Lamar Jones?
Yes, ma'am.
All right, this is a case where you're being charged with 1 count of battery family violence, and this is a negotiated plea with the offense date of July the 7th of 2021.
Yeah.
State, you may go forward.
Your Honor, the state's recommending 12 months, 165 days, 165 days credit for time served. The balance will be probated. No further contact with Kaysha, Kaysha, Nadia, Ndiaye. A stay away from 290 Delmar Lane Northwest, apartment G6, Atlanta. No alcohol, drugs, or weapons, a FVIP, and 60 hours of community service.
All right, Ms. Helen, is that what you understand the plea to be?
Yes, Judge, we agree with the state's recommendation and we do stipulate to the factual basis, venue, and ID.
Okay, great, thank you. Mr. Griffin, I am getting ready to ask you a series of questions. Are you prepared and ready to enter the guilty plea?
Oh, Judge, if he hasn't used his NOLO in the last 5 years, can we request that he be able to use that NOLO, Judge?
He's shaking his head. Hold on, they need to unmute you, Mr. Jones. Okay, there you go. So Mr. Jones, have you used NOLO in the last 5 years?
No, we just gonna plead guilty, Your Honor. I'm gonna use.
Oh, okay.
Okay, when you're regular, okay.
Thank you,
All right.
Judge.
Appreciate that.
All right, no problem. All right.
Oh, you said.
So raise your right hand for me, Mr. Jones. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand back down. And as I stated earlier, you are aware that you have a right to remain silent. And remember that anything that you state about the facts or occurrences of your case can and will be held against you. Are you clear on that?
Yes, ma'am.
All right, I have heard the state's recommendation and I will accept that as the plea in this case. They have stipulated to venue, identity, and a factual basis. And I'm going to ask you a couple of questions. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Greatly.
All right. Do you understand that you're pleading guilty and you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up the right to remain silent and not testify for yourself?
Yes, ma'am.
Do you understand that you're giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're giving up the right to see, hear, and confront your accusers and witnesses that may be called to testify against you?
Yes, ma'am.
All right. And you also are waiving or giving up the right to have the state to prove the charges against you beyond a reasonable doubt.
Yes, ma'am.
And you're prepared to agree to waive these rights today. Is that correct?
Yes, ma'am.
Has anyone told you or promised you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you that you will receive anything for pleading guilty?
No, ma'am.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And I will accept your plea to battery family violence. And again, we have 12 months, 165 days, credit for time served, balance probated, no further contact with Kaysha Nadia, stay away from 290 Delmar Lane Northwest, apartment G6 in Atlanta, no alcohol, drugs, or weapons while on probation, FVIP, which is a family violence intervention program. And so remember, you will have to complete that. If you miss classes, you'll have to start all over again. You have 60 hours of community service that you will have to document and provide as well. Do you understand all those conditions of your probation?
Ma'am.
All right, I will waive 6 months of your probation fees, if that is okay.
Yes, ma'am. Appreciate it.
I need to give this back to you, Ms. Champion. All right, is there anything else I need to take up with this plea?
Nothing further, Your Honor.
No, Judge.
All right, thank you very much. I will sign this.
Thank you, Judge.
Do
Thank
we have
you.
the plea sheet, Ms. Helen?
Yes, Judge, I'll be submitting all of them together to Ms. Champion after
At
court.
the end? Okay, that'll be fine.
Next, we have position the 26. Hold on, Matt. We're going back to position 39. He
Okay.
got over his attorney.
Okay. What do we have, Mr. Finley?
Yes, Judge Mincy. I spoke with Mr. Yunez again. I wanted to verify and went over, the different options. And he was confused about when I explained to him that the offer from the state was the time served deal. I think he was apparently confused, but I took my time and went over that with him again. And he does want to plead guilty, it sounds like, but.
Okay, but I will ask him some questions again to make
Yes.
sure.
Yes,
All
Judge,
right.
please do.
And I'm sorry, Madam Court Reporter. I hope you're keeping up with us. I
Sorry.
apologize. All right, good. We're going back to position number 39, Mr. Yunez. Can you hear me?
Yes.
Okay, and this again is case number 22 CR 000-175F. You're charged with 1 count of theft of services with an offense date of January the 11th, 2022. The state has made an offer of 12 months to serve 15 days, credit for time served for those 15 days, balance probated. You are to take a theft prevention class and a stay away from the sushi restaurant at 299 North Howland Avenue Northeast and 40 hours of community service. Are you willing to plead guilty to this charge with those conditions of your probation?
Will I be serving 15 days here in the jail to get my release?
No, you're getting credit for time served. As soon as the jail clears you, then you will be released in 24 hours or so. I don't know the exact moment, but you're getting
Okay.
credit for time served. So there's no additional time to serve.
Okay, yes, I will plead guilty.
Okay. And I will go over this. I'm also going to waive your probation fees. And I don't think the state had an objection that once you complete all of the terms of your probation, then you will be released from probation. So if you complete all the terms, the theft prevention class and the 40 hours of community service in 6 months, and I've waived the fees for you because you are a student, then you would be able to be off of probation at that time when you complete everything and provide that documentation to the probation office. Okay. All right. So I think, did I already swear you in? Let me do it again. Raise your right hand for me so that we'll have the record clear. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth? So help you under the penalty of perjury?
Yes, miss.
Are you under the influence of any medication, drugs, or alcohol at this time?
No, miss.
Okay, you can put your hand down. Are you satisfied with the services and representation of your attorney?
Yeah.
Okay. Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
Do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
Do you understand that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
Do you offer this guilty plea freely and voluntarily with a full understanding of the charges against you?
Yes.
And as to the charge of theft of services, how do you plead?
I to the charge to theft of services, I am pleading guilty.
All right. Okay, and let me go over your conditions one more time. You're getting credit for the 15 days served, credit for time served, 12 months, probation, balance probated. You are to take a theft prevention class and to stay away from the sushi bar on Highland Avenue, and you are to complete 40 hours of community service. I'm waiving your probation fees and the balance of your probation. Once you complete those terms, then you will have completed your probation.
Okay.
You understand those conditions?
Yes, miss.
Okay. All right, we appreciate it. Good luck to you. And that will conclude this matter unless Mr. Finley or Ms. Anderson have anything in addition.
Thank you.
Nothing further. Thank you, Judge.
All right, thank you.
Got number 26, Mr. Robinson.
Okay. All right, are you James Earl Robinson?
Yes.
All right, this is case number 20 CR 003058C. You're charged with 1 count of criminal trespass with the offense date of March the 1st, 2020. Is this a plea?
Yes, it is, Your Honor.
I'm
sorry.
Okay.
Sorry.
Okay. All right. And state, go ahead and state the plea.
Thank you, Your Honor. We are seeking 12 months probation, a stay away from the train depot located at 3724 Main Street in College Park, Georgia, 30337, with the balance suspended.
All right. Is that your understanding, Mr. Finley, of the plea?
Yes, that is our understanding, Judge Mincy. We do agree to the state's recommendation. So this is a negotiated plea. And additionally, Your Honor, we do stipulate to the venue, factual basis, and ID.
All right. All right, Mr. Robinson, can you raise your right hand for me? Uh-oh, I think they're on mute. Courtroom 2?
He's on 4 South.
Oh, I'm sorry. I'm in the wrong courtroom. I apologize. I'm sorry. Mr. Robinson, do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. All right. And Mr. Robinson, you've already heard that you have a right to remain silent, and anything you say about the facts or occurrences of your case can and will be used against you. Are you clear of that?
Yes.
All right. And I'm going to, again, ask you certain questions. Are you presently under the influence of any medication, drugs, or alcohol at this time?
No.
All right. Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
You're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
You're giving up or waiving the right to a trial by judge or jury, whichever you prefer?
Yes.
And are you freely giving up these rights?
Yes.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
All right. And again, you offer this guilty plea freely and voluntarily with a full understanding of the charges against you.
Yes.
All right. To the charge of criminal trespass, how do you plead? I didn't hear you.
Guilty.
Okay. All right. And you have 12 months probation. You are to stay away from the train depot at 3724 Main Street, College Park. The balance will be suspended. I will waive 6 months of the probation fees. And remember, you to stay away from the train depot. That is a condition of your probation. And if you violate that, you can be arrested again. Okay, so you understand that?
Yes.
All right. Okay, good luck to you. Does that conclude everything, Mr. Finley and Ms. Anderson?
Yes, Your Honor.
Nothing further, Judge. Thank you.
All right, thank you. Okay.
We have position number 37, Mr. Polaris White.
Okay. Is this a plea?
Your
Yes,
Honor,
it is, Your Honor.
sorry.
Judge, I believe that I emailed you and Ms. Champion our list of announcements, just so that you'll have it.
Johnny, I gave you the announcement.
Mhm. Thank you.
You're welcome, Judge.
All right. Position 37. This is case number 20 CR 002963B. Mr. Polarius White. Is that you? Okay. And you're charged with 1 count of simple battery family violence with the offense date of December 23rd, 2018. All right, this is a non-negotiated plea. And it says that with no further contact, the state can read me the plea terms.
Yes, Your Honor. The state is seeking 12 months to serve 15 days with credit for time served 15 days, balance probated, family violence intervention program, and no further contact with the victim.
What's the
And the victim, to the state's knowledge, is the nephew of the defendant.
And his name?
Emontae White. Emontae, spelled E-M-O-N-T-A-E, White, common spelling.
And 40 hours of community service, is that
Yes,
correct?
Your Honor, 40 hours of community service, thank you.
And no stay away or anything?
I don't believe we have an address at issue.
Okay. And I will waive 6 months of the probation fees. Can the balance be suspended once the conditions are completed? Or is there any objection to that?
I'm just checking these cycles. He has 2 open cases right now, Your Honor. So I think if we suspend, he'll still be having some issues to take care of, so.
So we will not,
Yes.
okay.
That's fine, yes, Your Honor.
All right, I'll just do the waiver of the 6 months of probation, please. All right, Mr. White, can you raise your right hand for me?
Yes.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. You can put your hand down. Are you under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Sorry?
Yes, ma'am.
Okay. Do you understand that by pleading guilty, you're giving up or waiving certain rights?
Yes, ma'am.
And you're waiving the right to presumption of innocence?
Yes, ma'am.
And you're waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
You're waiving the right to a trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you offer this guilty plea freely and voluntarily with a full understanding of the charges against you?
Yes, ma'am.
And you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
Okay. And so to the charge of simple battery family violence, how do you plead?
Guilty.
All right, I will accept your guilty plea. And again, that's 12 months to serve 15 days, credit for serving 15 days or credit for time served, balance probated. You have to take a family violence intervention program. You are to have no further contact with the victim, Emontae White, and conduct 40 hours of community service. Are you understanding of all of the conditions of your probation?
Yes, ma'am.
All right, good luck to you. That should conclude this matter.
And
Your Honor,
Your Honor,
Yes.
and I know his wife was on, and I believe she was mistaken. She thought it was going to be no further contact with her and a stay away from the house, but just want to verify there is no stay away from the. Right.
Yes, is she still on?
yes.
Okay, I'm sorry, Miss Nelson, yes. I've been seeing you. I thought you were an employee. I was giving you a new job today. How are you this morning?
I'll take the position.
Thank you for your time, Miss Nelson. And you are the wife of Mr. White?
Yes, ma'am.
Okay. Do you have any questions or anything that you wanted to tell me regarding that plea?
No, man, he's an awesome man. He's an awesome husband. I'm ready for him to come home.
Okay, well, good. I hope that everything works out for you all.
Yes, ma'am. Thank you.
All right, good luck to you.
Thank you.
All right.
You judge.
Yes.
I was trying to see if I'm taking the case for my nephew, Monte White. I wanted to know what's going on with the case that I got arrested for.
Mr. Polaris, this was a simple battery family violence regarding your nephew. I don't know if there's another case. I'm not for sure what you're referring to.
The case that I was arrested on.
Well, it would be the simple battery family violence, if I'm correct. Is that correct, Mr. Finley and Ms. Anderson?
Yes, Mr. White, this is the simple battery family violence we discussed and went over the plea paperwork and all the questionnaire I had for you yesterday involving this case.
Correct, but I thought that was dealing with my wife. The Monte case is, I thought that was a failure to appeal, which I never received the subpoena. I've been staying at that address forever.
Hold on 1 second, and hold on, Miss, I see a Bertina White.
That's my sister.
Hold on, that's your sister?
Yes.
Okay, hold on 1 quick second. Yes, Miss Champion?
He was arrested on a battery family violence charge.
Yes. Did they
He
add
got
anything?
No. It's a felony charge. And he has a $20,000 bond on that. So we have no control of that case. That case is being heard in Superior Court.
All right, I think I may clear this up and then I'll answer your question, Ms. White. I see your hand is raised. You also have a felony case, and that case is in the Superior Court, and you already have a bond on that case for how much?
$20,000.
A $20,000 bond on that case. So sometimes with these cases, there's a felony charge and there may also be a misdemeanor charge, but those are handled by two different courts. So this has resolved your misdemeanor charge, but you need to contact them to find out about your felony charge. Okay?
Yes, ma'am.
That
I
what
was
your
never,
understanding is?
I was never told that it was a felony. They took the they upgraded it after I got incarcerated.
That is what happens once more investigation is made at that time. But you have the two cases, and they may stem from the same facts or occurrences sometimes. But we're only dealing with your misdemeanor case today, which you have pled guilty to. So you still have to.
It had nothing to do with my wife case.
Doesn't have anything to do at the moment with your felony case, no.
Yeah, it confused me then.
Now, in that case, you still have a bond of 20,000 on your felony case.
Okay.
Okay.
I'm confused.
So I have no other
There was an order on that. Let me hold on a second, Mr. White. Let me see what your sister wants to ask. Yes, Miss Bertina White. What is your question, ma'am?
Yes, I was trying to see. We didn't press charge. Like, that's my son, Monte White.
Okay,
And
the victim is your son. Okay.
Yes.
And he is a minor?
He's 18 now.
Mm-hmm. At the time of the incident, how old was he? Under 18?
He was 17.
And so those are things that I am not in control of as the judge. Those are things that would have to be dealt with. You can speak to someone at the Solicitor General's office, although your brother has pled guilty to the misdemeanor of that. And then you would have to speak to someone at the DA's office on the felony matter. But sometimes people may or may not want to go forward. But if the police are called and charges are rendered, you know, sometimes you're not in control of backpedaling on that. But you would have to speak to someone at the DA's office now because he still has the open felony case, which he has a bond for.
Okay, thank you.
Okay. All right, you're welcome. All right, does that conclude everything, Mr. Finley and Ms. Anderson?
Yes, Your Honor.
Yes, Your Honor. Thank you.
Thank you. All right, you all may be excused. Thank you, Ms. Nelson and Ms. White.
Thank you. Yes,
All right.
ma'am.
All right. I'm sorry, that concludes your case, Mr. White.
Man, they tricked me, man.
All right.
Your Honor, we got position number 23, Mr. Michael Palmer.
Okay.
Man, about to cry, man. I don't know what about to cry, man.
All right, I have 23 as a negotiated plea. This is the case of 21 CR 007310F, State versus Michael Palmer. Are you Mr. Palmer? Courtroom 2.
Good morning, Judge Regina Mincy.
All right, good morning. This is a charge of criminal trespass, and the offense date is December the 4th, 2021. State, you may proceed.
12 months probation, Your Honor, 1 day confinement, credit for time served, which I believe is 4 days, and a stay away from the Express Pharmacy located at 30 Upper Alabama Street with the balance suspended.
All right. Is that your understanding, Mr. Finley, of the plea?
Yes, Judge Mincy, that is our understanding as previously stated. This is a negotiated plea. So we do agree to the state's recommendation. Additionally, Judge, we do stipulate to the factual basis, ID, and venue.
All right. All right, Mr. Palmer, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do, Judge Regina Mincy.
Okay. All right. And let me ask you a couple of questions. Are you under the influence of any medication or drugs or alcohol at this time?
No, I'm not under any influence of medication or drugs or alcohol at this time, Judge Regina Mincy.
All right. Are you satisfied with the services and representation of your attorney?
Yes, I am satisfied with the services and representation of my attorney, Zach Finley, Judge Regina Mincy.
Okay. Do you understand that by pleading guilty, you're giving up or waiving certain rights?
Yes, Judge Regina Mincy, I do understand.
Okay. And that you are giving up or waiving the right to the presumption of innocence?
Yes, I do understand that I'm using those right presumption of innocence.
And you can just answer yes or no for me. Do you understand that you have the right to remain silent and not testify against yourself, that you're giving up that right?
Yes.
Okay, and that you're giving up the right to trial by judge or jury, whichever you prefer?
Yes.
And that you are prepared and agreeing to waive these rights today, is that correct?
That is correct.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, no one has told me anything of that nature.
Has anyone promised you anything to plead guilty?
No one has promised me anything of that nature.
All right, do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
I understand that I have no probation or supervision or any open cases besides this one.
Okay, and so do you offer this guilty plea freely and voluntarily with the full understanding of the charge that is against you?
I do offer this plea freely and voluntarily of the charges that are said accused against me.
Okay, and so I will accept your negotiated plea. And how do you plead to criminal trespass?
I plead guilty to criminal trespass, Judge.
All right, and you have 12 months probation, 1 day of confinement, but I believe you've served 4 days. You're getting credit for the time served. You're going to stay away from the Express Pharmacy at 30 Upper Alabama Street. You're not to go back there under any circumstances.
Judge, so is my probation, that means I don't have to be on probation, correct?
The
It
balance is suspended. That is
Okay, I
correct.
just want to make sure, because I didn't hear you say that.
Yes, and I was getting there. But I'm making sure that you understand to stay away from the express pharmacy.
I understand that, I just like to be brief.
Okay, and so, yes, your balance is suspended, and that will complete the plea, and there are no other conditions.
I have one more question, Judge Missy. I want to know, with these other misdemeanor charges, is it possible that we can get this taken care of as soon as possible? Because I have a family death that's in my family of last year. My grandmother and my father just died, killed themselves, and I'm trying to make it to a funeral. Is there some way that they can like get me on the calendar as soon as possible? I can't miss those funerals. Like
I have no control over that.
the circuit public defender officers, they're not so adamant or not brief enough to handle these cases accordingly because of the pandemic. And I'm also just very
Yeah, I understand the pandemic has gotten all of us into a different way that we have to do business.
I understand that, but as far as commerce between me and the said state, it should not take no 60 to 120 days to handle these matters. That's that's obscene.
I understand, and your point is well taken and received, but that is not where I can control anything. But once you're out, you can speak to your attorney.
I've already spoke to Mr. Finley. He agrees as well. I just don't see why the circuit public defender office is not on board with his agreement as well as me as the accuser in the said state of this matter versus me, my opponent.
Well, all I can do is apologize. The pandemic has changed the way we do business here in the court system, and things are a little slower, and it's just the sign of the times. There's nothing specifically that we can do to speed up your case or anyone else's cases. So
Zach Finley can also require a motion for speedy trial for the person who's on my case calendar, and I spoke with the female lady. I'm just basically.
Okay, well, I do have to move on from your matter because I have a lot of other cases on the calendar. Yeah, I can't advise you about any of the other cases, but I will say good luck to you and continue talking to your attorney, okay?
All right, travel light.
All right, thank you, take care.
All right.
Who do we have next, Deputy?
Your Honor, we got position number 28, Mr. Ross.
Okay.
If I can go back.
Hey, hold on. She can call y'all.
I'm gonna call you.
All right, position 28, are you John Patrick Ross?
Yes, ma'am.
This is case number 17CR009854Y. And I have this down as a plea as well, a non-negotiated plea. You're being charged with 1 count of simple battery, family violence. I'm sorry, 3 counts of simple battery, family violence, and a 4th count of cruelty to children in the 3rd degree, all with the offense date of December the 9th, 2016. State, you may proceed.
Thank you, Your Honor. The state is seeking 12 months probated, 30 days confinement, credit for time served, which I believe is 43 days, with the balance probated, family violence intervention program, a stay away from 5130 Lost Dutchman, LOST DUTCHMAN Drive, Lithonia, Georgia. And a no contact with the victim, Tierra Cobbs, TIERRACOBBS. 80 hours of community service. And Your Honor, we're gonna null pros the 4th charge, the cruelty to children charge.
Okay. All right, Mr. Finley, is that your understanding of the plea?
Yes, Your Honor, that is our understanding. We are okay with the 80 hours of community service as well as the family intervention class. We're just asking that once those conditions are completed, if the balance may be suspended or not reporting.
Any objection? Any objection by the state?
Yes, Your Honor. On this particular case, the state does object due to the circumstances in this case, as well as the 27 cycles convictions, 2017 battery, and the facts surrounding this case, Your Honor, which the defendant did punch Tierra Cobbs and choke her in front of their minor 2-year-old child, Your Honor. So we are asking that that the balance
Not be suspended.
be suspended and be probated. Yes, thank you.
Okay. All right. I will refer to the state on that, Mr. Finley, and I will not suspend the balance. But I will waive 6 months of the probation fees. Okay.
Yes, Judge, thank you.
All right, Mr. Ross, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Need to ask you a series of questions. You've already heard that you have a right to remain silent, and anything that you state about the facts, occurrences, or circumstances of your case can and will be held against you. Are you clear on that?
Yes, ma'am.
All right. I need to ask you, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty that you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're waiving or giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
That you are waiving or giving up the right to trial by judge or jury, whichever you prefer?
Yes.
That you are agreeing to waive these rights, is that correct?
Correct.
Has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
And if you are on probation and you plead guilty and this affects that you understand those circumstances, is that correct?
Yes, correct.
All right. And so do you offer this guilty plea freely and voluntarily with a full understanding of the charges against you?
Yes, I do.
All right. And as to the charge of 3 counts of simple battery family violence, how do you plead?
Guilty, Your Honor.
All right. And we have no prosperity, cruelty to children in the 3rd degree. Are you clear with that?
Yes.
Okay. I will accept your non-negotiated plea. And I want you to understand that you will be on probation for 12 months. You are receiving credit for the time served, which is 43 days, although the state asked for 30 days of confinement. Your balance will be probated, so you will be on probation for the balance of the months. You are to complete the family violence intervention program. You are to stay away from 5130 Lost Dutchman Drive, Lithonia. You are to have no contact with the victim, Tierra Cobb, and you are to complete 80 hours of community service. Do you understand those conditions?
Yes, ma'am.
All right. That is it for your plea that has been accepted by the court. Is there anything else, Mr. Finley or Ms. Anderson, that I need to take up?
No, thank you, Your Honor.
Nothing further, Your Honor. Thank you.
All right, thank you. That concludes this case.
Thank you, Your Honor. Thank you, Mr. Benham.
All right, good luck to you.
Yes, ma'am.
Is that position number 30, Mr. Rico Smith, position number 30?
14 and add on 1.
All right, position number 30, Mr. Rico Smith. And 1 second. All right, this is case number 22 CR 0000198E with Mr. Rico Smith. Is that you, Mr. Smith?
Yes, ma'am.
All right, and we have a non-negotiated plea. Is that correct? You're being charged with 1 count of unlawful to possess, display, or use any false, fraudulent, or altered identification documents and giving false information to a law enforcement officer, both with the offense date of January 13th, 2022. State, you may proceed.
Thank you, Your Honor. The state is seeking 12 months to serve 30 days, credit for time served, which I believe is 13 days, with the balance probated, 50 hours of community service, and a stay away from the Hilton Hotel located at 255 Cortlandt Street in Atlanta.
Is that your understanding of the plea, Mr. Finley?
Yes, it is, Your Honor. And we were just asking, Mr. Smith stated that he was okay with the community service and just that once that was completed, if it could become, the balance would be suspended or become not reporting status, Your Honor.
What
Your
say
Honor,
you,
the
state?
issue, yes, Your Honor, the issue the state has with that is the criminal history of this defendant out of Maryland, out of Virginia, 7 total cycles in Georgia, a 2006 conviction out of Florida for defrauding an innkeeper. Also with the facts of this case, Your Honor, the defendant was given the opportunity to tell the truth to officers about his identity multiple times and chose not to do so. So for those reasons, Your Honor, we think the balance should be probated.
Okay.
And one more thing, Your Honor, I believe, because on the recommendation sheet, it says 13 days. But I believe, obviously, this would be a time served deal as that is behind. I don't think that's counting, obviously, till today of the time served.
I can quickly double
If
check
you
that,
don't,
Your Honor.
if you could, Ms. Anderson.
Yep, absolutely.
Thank you.
Okay.
Okay. 15 days, Your Honor. 15 days now.
Okay.
Thank you,
Okay.
Attorney Finley.
All right, thank you, Ms. Anderson.
All right, Mr. Smith. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay. All right, you can put your hand down. And you've already been told that you have a right to remain silent. Anything that you say against you, anything that you say about the facts and circumstances of your case can be used against you. Are you okay with that?
Yes, ma'am.
All right, I'm going to ask you a series of questions. Are you under the influence of any? Oh, I'm sorry, Mr. Finley, do you stipulate to the venue, identity, and factual basis?
Yes, we do, Your Honor.
Okay. And let me ask you, Mr. Smith, are you under the influence of any drugs, alcohol, or medication at this time?
No, ma'am.
Are you satisfied rather with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty that you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you are waiving or giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
Do you understand that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared to agree to waive these rights?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Does anyone promise you anything to plead guilty?
No, ma'am.
All right, and do you understand that if you're currently on probation or your probation may be revoked because of your guilty plea here today?
Yes, ma'am. I do have a question.
Okay,
Would I be able to because I'm on probation, would I be able to utilize my NOLO for this case?
Ms. Anderson and Mr. Finley, what's your statement on using a NOLO plea? Have you pled and used NOLO within the last 5 years?
No, I have not.
Ms. Anderson?
I don't have any information that he's used it one way or the other, Your Honor.
Mr. Finley?
Yeah, I do not either, but if he has not, then we would ask for NOLA.
Okay. All right, we will allow you, if you have not used it in the last 5 years, Mr. Smith, to use your NOLO plea, okay?
I'm sorry, can you repeat that? Because I couldn't hear you.
I said, we will allow you to use your NOLO plea if you have not used it in the last 5 years,
Thank you.
okay? All right, and also let me ask you this, do you offer this guilty plea using NOLO freely and voluntarily with a full understanding of the charges against you?
Yes, ma'am.
And so to the charge of altering or using fraudulent ID documents and giving false information to law enforcement officer, how do you plead to those two charges?
NOLO.
All right. I will accept your NOLO plea. And remember that you'll be on probation for 12 months. You're getting credit for the 15 days that you have served. The balance will be probated. You will have 50 hours of community service, and you're to stay away from the Hilton Hotel at 255 Portland Street in Atlanta. All right.
Yes, ma'am. Now, is that supervised probation or unsupervised?
Supervised to the extent that you must report to the probation office, and they will give you those rules and conditions for reporting.
Because I wanted to make the court aware. I'm not sure if I have a report date, but apparently I have a hold from another state. So I don't want that to interfere when I have to report to probation.
Well, you need to let them know, and then they will provide you with an alternative way to report if you're going to not be in the state of Georgia or somewhere else, if you're going to be held somewhere else.
Okay.
So you will need to, when probation comes to speak with you, you will need to let them know.
Okay.
Okay. All right. Is there anything else that we need to take up on this matter?
Nothing further, Judge.
Okay.
Thank you.
All right. That will conclude your case. Good luck to you, Mr. Smith.
All right. Thank you.
Next, we got number 14 and add on 1, Mr. Griffin.
14 and add on 1. Okay.
Judge, I just want you to take note that position 14 and add-on 1 is entering pro se. And so he wanted me to announce that for you, Judge, and for you to lead him through the process.
Okay, thank you. All right, are you Mr. Alex Griffin?
Yes, ma'am.
All right, you are being charged in the first case, which is 22 CR 000285B, and you're being charged with 1 count of terroristic threat.
Can I say, is that March 5th, 2000?
I was getting ready to say that the offense date is March the 5th, 2021. You're also being charged in the same case with obstruction for law enforcement officer and simple battery against a police officer. All of those 3 occurring on March 5th.
Okay, very good.
All right. I will listen to the state's recommendation, and then I will come back to you.
And
So
what about the simple battery 21CR00798B?
I'm going to do that case second, but I have to do each case individually. But I do have that as the next case from December 22nd, correct?
And we do know about the case number that been reduced because it was a felony case number and now it's a misdemeanor case number. That seems been a problem.
On the simple battery?
All of these was, they said, was consolidated from a, it was, according to the logic they were using, it was a felony case number, but they've been misdemeanors the whole time. I've been here all year trying to fight this.
Well, we're getting ready to handle it today. And I'm only handling this is state court for misdemeanors. So
okay,
we are where we need to be, okay?
No problem.
Okay, so you are pleading guilty to misdemeanor cases, okay? All right, go ahead, Ms. Guidry.
Yes, Your Honor. So for his first case, we're recommending 12 months to serve, 180 days. Credit for time served. We may need a clarification on the time. No further contact with Officer Thomas and Officer Holloway, and a 12-week anger management.
Okay. I see on here 60 hours of community service.
Yes, that's correct.
Okay.
They changed it. And 60 hours of community service, yes.
Okay. Is that your understanding of the plea, Mr. Griffin?
No, ma'am, but I am a part of the CERT team, so I don't mind doing community service as long as I get ID. Because like I said before, some of these things fall under state secrets, and if I'm gonna do community service, the police constantly takes my ID, and that seems to be the problem what they're doing. I need my ID and my social security. I need my ID back. I need my cell phone, and I've been here so long because this happened in March 5th of last year during basketball all-star weekend. This is nothing new about this case.
Right.
And
well, I am not 100% in control of that, but if those personal items were logged in when you were arrested, then those should be returned to you.
Like I said, I was out on bond and all my stuff is always missing, and it's always a problem. Whatever site that they doing, if I'm doing community service, I'm gonna need some form of ID to let them.
I agree with you. So what I suggest that you do when you get out is to go to the driver services and our Georgia Department of Revenue to get your ID. To
Yes,
get
ma'am.
a new ID once you get out.
Tell them per Judge Regina Manson. Yes.
I don't know that they'll care so much about that, but certainly you'll have to meet the requirements. And this is generally what some people have issues with, is that they will want some other type of verification of your identification, such as obviously, like you said, a social security card, either a birth certificate. And those are the things that people will usually have to get in order to prove your identity. So there may be some issues with that. Do you have your birth certificate and social security card?
Military Fort Bragg, Secretary of State, C, 501C.
Well, it sounds like you may have enough information. If they have unfortunately lost your ID, then you will have to go down and get another one. I'm not in control to do much about that, and I can apologize if that is the case, if they keep losing your ID.
Yes, ma'am.
You will have to go down and get another one, unfortunately.
I do object. I do want to know where would I be doing this community service at, so we can deal with this identification classification that I've been through before.
Right. Well, you will have to find a nonprofit, and not your own nonprofit, but another nonprofit to do that community service with. And when you talk to your probation officer, they will explain to you and give you some suggestions or locations as to where you can conduct and do the community service. I know that.
Will this be the one on Mitchell Street or Pryor Street?
Say that again.
Where's this probation office? Is this the one on Mitchell Street or Pryor Street?
Don't get me to quoting wrong addresses, but they will tell you before you're released where you have to report. And I do not know what the address is, and I'm not going to speculate, because if I'm wrong, I know that you will get me for that. So I don't know exactly where the office is, but due to some of the COVID restraints and conditions, things are a little different. So they will explain to you how that can be completed and where, okay?
Yes, ma'am.
Okay, the probation office will lead you in the right right direction as soon as you have your meeting with them, okay?
And this time will start per March 5th, so it's time served. That's what.
Yes, you're getting credit for time served. That is correct. Okay, Mr. Griffin? All right, did I swear you in? Raise your right hand for me.
Your Honor, would you like for me to read his other case as well before he decides?
Yeah, let's go ahead. And Mr. Griffin, you want to hear your second case, which is that 21 CR 007908B, the simple battery case from December 22nd, 2021.
It was
And then
supposed to be 30 days time served. We had already handled that.
Well, go ahead, Ms. Guidry, and let me see what the notes are on that case.
Okay, Your Honor, so in that case, we're recommending 12 months to serve, 180 days, credit for time served. He has 37 days on that one. The balance is probated, no further contact with Casey Rutherford, a stay away from 185 Central Avenue, Southwest Atlanta, unless he's there for business, 8-week anger management, and 60 hours community service, and that's going to be consecutive to the other charge.
Okay.
Given his criminal history and the facts of the case, if Your Honor would like to hear them.
No, and they're gonna.
I objected that because the first deal was 30 days, and now she's raising it. So I gotta hear what's the new deal, and can I see the old deal?
Well, no, she's just saying that you're getting credit for the days that you've served. The 37 days. How many ever days that you've served, you're getting credit for time served against the 180 days. So you're not going to serve any additional time, okay?
My deal was with charge 4, it was supposed to be 30 days. She's saying a different amount other than 30 days on that.
No, she's not. She's stating that they're giving you credit, although you served 37 days, that's okay. You served more than the 30, so it's fine. You won't serve anymore.
Okay, as long as we're clear. And it starts December or whatever.
Well, I think, did you say, Ms. Guidry, the same 60 hours of community service because it's running concurrent?
It's running consecutive, Your Honor.
I mean consecutive, I'm sorry.
Yes, the same 60 hours.
What does consecutive mean?
Right, running together, not one behind the other. They will merge and run together. So the 60 hours that you do will count for both cases.
I will accept that as long as I go home today and continue. I already missed Christmas behind these lies.
Did I explain that right, Ms. Guidry?
No.
I did
no,
not.
Your Honor.
I just thought about it. I did not. I told him concurrent and I said consecutive. They will run behind each other. So I stand corrected. I thought about what I said after I said it. So I apologize, Mr. Griffin. I don't want to get you so confused because you're representing yourself. But no, that will be a total of 120 hours, 60 hours on each case.
And how much time would I be in this jail? Would I go home?
Not. You will go home. She's giving you credit for time served. There's no additional time to serve. It's just that you have quite a bit of community service.
Now, Your Honor, I did recommend 180 days.
I'm sorry.
Where 1 minute it went from 30 days. It went from 30 days to 180 days. Where did that?
I don't think I ever said 30. Did I, Ms. Guidry?
No, you didn't, Your Honor.
Okay, at least that wasn't my mistake. And you may have heard that previously from a different assistant solicitor, but Ms. Guidry today is offering you 180 days on the second case.
Yes, that's correct.
Why is that? And why is that?
Due to the nature of the facts and circumstances, I'm assuming.
And his criminal history.
And your criminal history.
Well, is there any way I can ask for a signature bond on that?
This is not for a bond. This is for a plea of guilty to it.
I refuse to plead guilty to 180 days, man, for that.
No. 180 hours of community service.
Days.
See what
180
well,
days.
The 180 days with credit for 37 days for time served.
Yes.
So you will have extra time to do on the second case. You are correct.
No, I don't want to plead guilty to that.
You don't want to plead guilty to the second one?
No, not 180 days. No,
okay. 180 days minus 37, whatever that math is.
I just had a daughter. It is very important that I sign my daughter's birth certificate and be there for Valentine's Day, ma'am. I just had a baby girl. Her name is Melody.
Sorry.
Last name.
So you're gonna plead not guilty to the simple battery, but plead guilty to the other case?
Yes, ma'am.
Okay. And what is his bond on this case, Ms. Guidry?
On which case? The second one?
Second one, yes.
The second bond, give me 1 second, Your Honor.
Okay.
I asked for a signature bond just so I can be back with my
Your Honor,
daughter.
on his simple battery, the bond is $5,000. And Your Honor, again, we would deny any signature bond given that he was released from jail and then he committed this crime on December 22nd.
Which I'm still innocent from, and I'm disputing all facts. That's why I object, because these matters did not happen at all in front of the sheriff. And look at the address in front. I'm reporting to the sheriff to handle this case that we're handling right now. And that's exactly what's going on. That's why I was in front of, outside in the parking lot, right by, what is it, American Deli. That's why all this stuff happened. I'm disputing all that because the sheriff is the one that actually bought my daughter food and all that on that day. Who was not.
Okay, well, this is only bond or plea hearing. I'm not going to go into the details of the facts because that is not what this hearing is for. So I'm looking at your December 26th.
Could you read that?
Okay, on this simple battery charge, which is the second case here, just the one charge of simple battery of a $5,000 good bond, a surety bond, no further contact with Cassie Rutherford, no alcohol or illegal drugs, no firearms or weapons. And that's what it is. It's a $5,000 surety.
And what address are they using, ma'am?
That's perimeter security check of the Justice Center complex.
So, and what is the Justice Center? Is it the building you in now or what? That's what I want.
Yeah, well, not necessarily, but I'm next door to it. They have 160 prior, and I believe that ASG Guidry read 185 Central. So I guess it depends on which is it the 185 side or the prior street side?
I object to all that because I know exactly what I was, and I was on my way to the building you currently in now. And I have no idea why he wrote down and saying something about a food line when I just left American Deli.
Right, but they don't want you coming into the courthouse complex unless you need to conduct business, I would say, because you may have to report to court, but not to come for any other reason.
Ma'am, you a judge like me. Why else would I come to a courthouse other than conducting business or find out certain things pertaining to this actual case that we're handling in my hand?
I understand, but when you come here, you have to be respectful to the authority and respectful to the persons that work here. And if not, then you will find yourself arrested again. If you come here to not respect their authority and their instructions when you come into the building.
Yes, ma'am. Prince Hall, Auburn Avenue, Reverend Warlock. Christmas.
Again, Your Honor, I believe he's not taking the plea, so he may just need to be arraigned and set for a further date.
Right.
I asked for a signature bond so I can be with my daughter. I'm the sole provider of my family. My daughter's out there. I can't even, because of these lies and misdemeanors, been extended since last year.
Well, I don't know that I'm inclined at this point to give you a signature bond. How many cycles does he have, Ms. Guidry?
29.
Our pre-trial knows either way.
Pre-trial may clarify, but I have 29.
23?
29.
29?
Yes, sure.
All right, is
That's
that what you
correct.
have, Ms. Harvey?
Well, I have 30, but it's including the last arrest.
Including the last
5 of the cycles are in other states.
Okay.
Can I hear
What's the last conviction? Or the most recent conviction?
For same offense or just in general? Let's see. I think he has a recent, let's see. I have a 2020 battery. Right.
2020 battery conviction?
And again, Your Honor, he was. Yes. on December 2nd, and he committed this charge December 22nd.
I still had the right to maintain my innocence. I didn't commit none of these accusations. I'm telling you, it didn't happen like that.
But we still have to go with your criminal history, which would be arrest and conviction. And yes, you have a right to fight these charges. And, you know, you may want to get some representation to help you when you get to the courtroom. But I tell you what we'll do is we will defer. I'm going to leave your bond in place of the 5,000 on the add-on case, which is the simple battery from 12/22/2021. I will let you continue with that bond of 5,000, good bond on that case. And then do you still want to plead to the March 5th, 2021 with the terroristic threats and the instruction? Do you still want to plead guilty on that case?
Yes, ma'am.
Okay.
Are you gonna arraign him on the add-on?
Oh, let me arraign you real quick while we have you here on the add-on simple battery case. I'm going to arraign you on that case, okay? And read the formal charges against you. And you're being charged with one count of simple battery. Do you want to waive the formal reading of the accusation, or do you need me to read it to you?
I need to hear everything. I already
Hear everything? Okay.
And I would like.
All right, hold on 1 second and I'll read it to you. Okay. I will definitely do that because we want you to have an understanding.
May I have the transcripts of this court proceeding, please? I do like.
If you pay the court reporter, she will give it to you if you pay her.
I would like to make my oral notice of appearance. Alex Griffin, pro se.
We have you down as pro se, so we do have that. But if you want to get a transcript, I'm not for sure how you will contact the court reporter. That may be something to ask Ms. Greenhouse. How do they normally do that when they're pro se?
They would need to basically, they could call my number or call our office number. If he,
do you have a pen there with you? Do you have an ink pen, Mr. Griffin?
No.
You do?
My name is Susan Greenhouse, and I need an address.
Well, I'll give you my phone number, my direct line at work. It's 404-612-5058. And you can leave me a message, sir, with your contact information, how I can reach you, and then I can get back to you and we can go from there.
Yes, ma'am. I do need a court order sent to this judge because it seems to be a problem with me going to the law library since I'm pro se and fighting for my life for 180 days. I need to go to the law library as soon as possible. Give me a criminal charge.
Those are two separate issues. Ms. Greenhouse doesn't control the law library, and neither do I. But again, it appears to me, and I'm not accusing you, but when you come onto the courthouse complex, whether on Central Avenue side or on the Prior Street side, you must be respectful of all people in all situations so that you don't run into these issues or problems with some of the employees not wanting you to be in the building. So you really have to control your actions so that you don't have these stayaways or no further contact with various employees in the Fulton County Courthouse complex. So you do have to be careful of that. You can come in as long as you're conducting business, but with the court reporter, you have to call her and leave your information. and then she will tell you how much the transcript will cost. Once she's paid, then she will mail it to you. That's
Yes,
how that
ma'am.
works.
Yes, ma'am.
Okay.
Quinn Hall, Auburn Avenue, Roman
But
World.
she's not taking that information at the moment.
Can I say this? I'm filing for an indigent copy, filing indigency for a copy of the,
Well, I don't know that you can verbally do that. And I don't know that if you were to be declared indigent, I know that it waives court filing fees and costs, but I'm not for sure if that order would include a free transcript. I don't believe that it does.
I
But
object that how come 1 minute I'm indigent to have an attorney, but not indigent to get my pro se copy of these transcripts?
Ms. Greenhouse, is that your experience? Because I know you've been around a while, that if they
Yes, Your Honor. I have done a civil transcript where the party was declared indigent. I don't believe I've done it in a criminal case, but in that civil case, the judge had to approve the state of the party being indigent. So I'm not really sure if I'm not really sure. I would have to actually research that a little bit further if and when he calls me.
Right. We will have to look into that, Mr. Griffin, because when you apply for poverty status and do the affidavit, I know that it goes through the clerk's office and it applies to fees and costs, but I honestly don't know that it includes a free transcript. So you will have to check with whomever you complete the application with through the clerk's office to find out what charges are waived with the indigent status. Okay.
Ma'am, respectfully, ma'am, if you going by my cases and saying my cases, this and that, obviously a layman can see that I've been pro se and experienced, and I'm telling you exactly the process. Due to the location of these current crimes, I am in the building handling, because I also have another case that for some reason is not popping up. And I've been going to the court, the Annex building, the Mitchell Street building, the Marks building, trying to handle all these cases. And that was the main reason I was there at that particular case to handle.
Okay, well, I'm not going to go into the facts of what happened on those dates. We're just talking about at the moment whether or not you will get a free transcript, and I cannot tell you that. I don't know the answer to that question. But once you are declared indigent, have that status, and have received that order from the clerk of the court, filling out the pauper's affidavit and the paperwork that goes with that, then you need to ask them all of the fees that are included under that statute that are waived, because I do not know that at the moment, and I will not tell you that it includes transcripts from court reporters. I don't know that. So you will have to find that out.
Yes, ma'am.
And I can't give you legal advice on that either.
Yes,
but when you get out and do that, they will tell you.
Yes, ma'am. Only thing I'm asking for is a court order to get my financial statement so I can send it to Susan, because I got to prove my indigency.
You don't prove that to Susan Greenhouse. No, you're not proving your indigency to her. You're doing that with the clerk of the court. I know that's where the application process starts. And then they will tell you what fees and costs can be waived once you declared indigent and you receive that order from the clerk's office.
And is that state clerk office, room 104, 106 Prior Street, Atlanta, Georgia, 30303?
That the room number, Ms. Champion, for the clerk's office here?
150 Prior Street.
160 Prior Street.
Yes, room J150.
Room J150. So write down J150 for the clerk of state court, because that's where you J150 in the 160 building.
J150 or 160?
J150 in 160 Prior Street for state court. Okay.
Is it still?
So state court is in state court. You come in a different location than you do for superior court, but you know all those buildings are connected. But I want you to come in and be nice and respectful to everyone so that you can remain in the building. That's the first thing.
So is it still Kathleen Tina Robinson, clerk of Superior Court?
That's Superior Court. We just read to you about state court. These are misdemeanor charges.
I'm trying to complete the whole address so it goes to the right court.
Well, that's Superior Court. we are talking about state court. Your misdemeanors are in state court. That you need to send it to the clerk for the state court, not superior court.
Your Honor, may we arraign him, and if he has any further questions, he can just ask an attorney if he wants an attorney.
You need to hire an attorney to help you through the process. But we're talking about state court right now. We're not talking about superior court.
Man, it was your clerical problem the whole time. These been misdemeanors. I've been here all year. They've been saying they've been felonies. I'm not making.
And that's not my clerical issue. That is the prosecutors who determine, based upon the facts of your case, whether it's going to remain a misdemeanor or be transferred for felony. So that is determined by a lot of factors of the case. But I'm going to arraign you on this add-on case real quick, and then we're going to take your plea on the other. The rest of it.
For the record, my original attorney was Latrice Collins, and I never did fire her, and she's still supposed to be my attorney. I don't know where all these other people come from, but Latrice Collins is my attorney for the record. Now, I told the young lady to call either Sabrina Woods or Latrice Collins, and I can't figure out why they didn't do that to clarify all this.
Well, you're going to have to do that. We don't call your attorney and say, where are you with your client? You have to do that.
I'm referring to the other public defendant that was just here. I said, where's Latrice Collins? That's who I'm referring to as of now.
Well, you need to find out how to get in contact with your attorney. If you have an attorney, you need to get in contact with them or send a message to them so that they can come and meet with you and talk to you. All right. So on this first case, which is 21 CR 007908B, you're being charged with 1 count of simple battery, and that offense date is 12/22/2000. And I'm going to read you the accusation, and it states that I, Keith E. Gamage, Solicitor General for the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Alex Griffin with the offense of simple battery, a misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about December 22nd, 2021, did intentionally make physical contact of an insulting or provoking nature with the person of Cassie Rutherford by striking her in violation of OCGA section 16-5-23, contrary to the laws of the state of Georgia, order, peace, and dignity thereof. Keith E. Gamage, Solicitor General. Okay, so you have now been formally arraigned, and you are aware now of what the accusation states. You can get a copy later.
I object that. I just want the address and the location, because mine says something about a line or something.
Well, you will have to, once you're released, you can request a copy of your file or come down to the clerk's office to do that, and they will give you more particulars and whatever is in the file with the accusation, as well as you securing a copy later of the police report or incident report so that you can find out the facts, okay? But I really suggest, these charges are serious, that you get an attorney to assist you, Mr. Griffin.
Latrice Collins.
Well, we're not gonna call for you. If she's retained and been paid, then she would be here, okay? Because she would know of your court dates and get court notices. So there may be some issues there that you'll need to figure out. But you have been charged with this offense, which is the simple battery. I've read you the charges. I want you to also know that since the Solicitor General has accused you of these charges, it carries a maximum sentence of 1 year in jail and or rather a maximum fine of up to $1,000 for this charge. This case is going to be reset for a jury trial, and that trial will be scheduled by the state court judge to whom your case is assigned, the division judge, as a further notice for trial, okay? And at the jury trial, you will have a right to an attorney, and you need to carry that burden to get yourself some representation to conduct that jury trial at a later date, okay?
Yes, ma'am.
All right, so let me go back to the other case. So you've been arraigned on this one.
Your Honor, would you like for me to read the recommendation again?
Please.
Okay. It's 12 months to serve. Credit for, I believe he has 272 days on this one.
Okay.
The balance will still be probated. No further contact with Officer Thomas or Holloway, a 12-week anger management, and 60 hours of community service.
Okay. All right. So you understand what the plea is, correct,
No,
Mr.
ma'am.
Griffin?
No, ma'am, I don't.
So are you going to accept this plea of guilty with the conditions just read by Ms. Guidry or not? You got
No,
about 2 seconds to tell me. You're
No,
not?
ma'am. No, ma'am.
Okay. So we're not. So that case will be further noticed for the trial court. So you're pleading not guilty.
That is correct. And I do want to know the prior attorney of that case, the record, who's the attorney of record for that case. That's all I ever had.
Yeah. Yeah, I need to arraign you. Hold on. Since you're pleading, since you're pleading not guilty to the 22 CR 000285B, I'm going to arraign you on this case. Do you want to waive the formal reading of the charges, or do you want me to read them to you?
Please read them to me and the correct case number.
This is the 22 CR 000285B. B is in boy. With the terroristic threats, obstruction of a law enforcement officer, and simple battery against a police officer. Give me a second, and I will read these formal charges to you for the arraignment and enter your not guilty plea.
Can I say something now?
Not right now. Let me go ahead and do this arraignment first, because I do have to move my calendar along. The first charge is terroristic threat. And again, this is case number 22 CR 000285B. The first count is
Case number 21 CP 198151, because that's what it says on mine. Case number 21 CP 198151.
Now, but that was prior to the case being accused. Now that it is accused, I'm giving you the accusation number. So if you want to write it on there real quick, since you do have a pen, I'm going to read it to you one last time. The accusation
number is a complaint number.
That's
You probably had this felony case.
Yeah, that may be for your felony case with a CP number.
What felony case?
I think you're getting things a little confused. Let me arraign you on what I have here in the, because I'm not your attorney, and I've been very, very patient with you, but now I'm getting ready to run out of patience and time, okay? So we've got accusation 22 CR 000285B. The first count is terroristic threats. I, Keith E. Gamage, Solicitor General for the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Alex Griffin with the offense of terroristic threats, a misdemeanor for that said accused in the County of Fulton, State of Georgia, on about March the 5th, 2021, did threaten to commit a crime of violence with the purpose of terrorizing another by threatening to shoot Atlanta police officer K. Thomas with a firearm in violation of OCGA section 16-11-37M, contrary to the laws of the state, the good order, peace, and dignity thereof, signed by Keith E. Gamage, Solicitor General. The second count, obstruction of a law enforcement officer. I, Keith E. Gamage, Solicitor General for the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Alex Griffin with the offense of obstruction of law enforcement officer, a misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about March the 5th, 2021, did knowingly and willfully obstruct and hinder T. Thomas, a law enforcement officer, in the lawful discharge of said officer's official duties by pulling away from said officer and striking him with the accused hand in violation of OCGA section 16-10-24A, contrary to the laws of this state and good order, peace, and dignity thereof. Signed, Keith E. Gamage, Solicitor General. And the third charge, hold on. And the third charge is a simple battery against a police officer, which is count 3. I, Keith E. Gamage, Solicitor General for the County of Fulton, State of Georgia, in the name and on behalf of the citizens of Georgia, do hereby charge and accuse Alex Griffin with the offense of simple battery against a police officer and misdemeanor for that said accused in the County of Fulton, State of Georgia, on or about March the 5th, 2021, did intentionally make physical contact of an insulting or provoking nature with the person of M. Holloway, a police officer engaged in carrying out said officer's official duties by kicking said officer in violation of OCGA section 16-5-23E, contrary to the laws of this state, the good order, peace, and dignity thereof. Signed, Keith E. Gamage, Solicitor General. You have been arraigned on both cases. Your not guilty pleas are entered, and you will receive further notice from the division judge of when those cases will be set to come before the court. And all I can say is to end this for you, Mr. Griffin, is that you need to get counsel and get some representation to help you with these cases, okay?
What felony case?
I'm not going to talk about that, but let me tell you that all 3 of the charges that I just read each carry a maximum sentence of 1 year in jail or a maximum fine of $1,000 for each. So that could be a total of 3 years in jail and a $3,000 fine total, because it's a year and a $1,000 fine and or for each of those charges. This case will be reset for a jury trial, and the trial will be scheduled by the state court judge with whom this case is assigned as further notice of the trial date, and you will receive that as long as you keep your address updated if and when you're released, and then they will tell you what your court date is, okay? So I need to move on my calendar, and I wish you good luck, and please get some representation, okay?
Latrice Collins. Thank you, ma'am.
All right, thank you. Have a good day.
Yes, we have number 12.
Your Honor, we're going to position number 32. Mr. Stanford, position number 32.
Number 12, Mr. Grace.
Position number 32.
Number 12, Mr. Grace.
Hold on.
Position number 32, Your Honor. Position number 32.
Position number 12, Mr. Grace. Grace.
I have to start misdemeanor, Your Honor. Can we go to position number 32?
I'm going to position number 12.
Which courtroom are we in? Are we in South?
Position 32.
No, we are number 12. Number 12, Mr. Grace. Sit down, Mr. Grace. Yes, ma'am.
How many do I have in South left versus courtroom 2? Only have 2 left.
You have 1 left in courtroom 2, Your Honor, and I have to start misdemeanor.
Okay. Let me do position 32 in courtroom 2, please. And then we'll be finished there, and I will come to courtroom South after that. I apologize. All right, is this Mr. DeMarcus Stanford?
Yes, ma'am.
Okay. All right, Mr. Stanford, you're being charged in case number 22 CR 0002018 with 1 count of criminal trespass. And you'll understand that this is going to be a plea.
Yes, Your Honor, this is a negotiated plea.
Negotiated plea. All right. And this is Ms. Anderson, and who's representing the state? I'm sorry, who's representing the PD's office? Whose case is this? They may have been a little confused. We're on position 32.
That's my case, Your Honor.
Okay, thank you, Mr.
I
Finley.
apologize. I was a little bit confused there for a second.
I'm sorry. I do understand. Go ahead, Ms. Anderson, and read the plea deal?
Thank you, Your Honor. The state is seeking 12 months to serve, credit for time served 15 days, with the balance suspended, 40 hours of community service, and a stay away from 1380 Atlantic Avenue.
All right. Is that your understanding, Mr. Finling, of the plea?
Yes,
offer?
yes, it is, Your Honor. And we do agree to the state's recommendation, as this is a negotiated guilty plea. And additionally, Your Honor, we do stipulate to the factual basis, ID, and venue.
All right. Thank you. Raise your hand for me, Mr. Stanford. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. All right, you're being charged with 1 count of criminal trespass with the offense date of January the 13th, 2022. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you are giving up and waiving the right to presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to a trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty today?
No, ma'am.
Has anyone promised you anything to plead guilty today?
No, ma'am.
And do you understand that if you are currently on probation, your probation may be revoked because of your guilty plea here?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with a full understanding of the charges against you?
Yes, ma'am.
And so as to the charge of criminal trespass, how do you plead?
Guilty.
All right, and I'm going to again let you know about the conditions of your sentence. And that is 12 months to serve 15 days, credit for the 15 days, 40 hours community service, a stay away from 1380 Atlantic Drive, and the balance will be suspended. Is that correct? Ms. Anderson and Mr. Finley?
Yes,
Yes, that is correct, Your Honor.
Do you need a waiver on any of 6 months of the probation fees?
Your Honor, it says balance is suspended, correct?
Oh, I'm sorry, balance suspended. Thank you. We don't need that.
But he
Thank you,
got
Judge.
40 hours of community.
But he
service,
still has to do his 40 hours of community service.
So he has to be monitored.
So he has to be monitored for that.
Okay, so once that's complete, me not reporting?
Right. I'm asking, I will order that if the state has no objection.
No objection, Your Honor.
And I will waive 6 months of the probation fees because he will have that during that time.
Thank you, Judge.
Okay. So once you have completed your 40 hours of community service, Mr. Stanford, your balance will be suspended and you won't have to report, okay?
Okay, well, do I get time served?
You do, you're getting credit for time served of the 15 days, yes.
Okay.
But you still got to do your 40 hours of community service. Don't forget that,
Okay.
okay? All right, good luck to you.
All right. Thank you.
Thank you, Your Honor.
All right, you're welcome, thank you. And okay, position 12. All right, are you Mr. Willie Grace? Yes?
Yes.
Okay, this is case number 22 CR 000-164J. You're being charged with 1 count of simple battery and a 2nd count of obstruction of a law enforcement officer with the offense date of January the 11th, 2022. And I understand that this is a non-negotiated plea.
Correct, Judge.
Okay, all right. And so state, you may proceed.
Yes, Your Honor, we're recommending 12 months, 60 days, credit for time served of 17 days. The balance is probated, a MHET. If that's not necessary, 8-week anger management, no further contact with Carol Kelly, no alcohol, drugs, or weapons, and 40 hours of community service. Your Honor, the reason for us giving 60 days is due to the defendant punching a citizen simply because he asked them for 75 cents. She stated she didn't have 75 cents, so he punched her in the chest. And Your Honor, given his criminal history, he has 55 cycles and half of them are convictions, Your Honor. He also has open cases, including 2 simple batteries, and he was also convicted of a 2021 simple battery for pretty much the same instance of where the victim was walking to the bus stop, and as she was leaving the store, the defendant punched her in the shoulder. He ran away to a store and then he pushed another individual. Your Honor, we really think that this 60 days is very lenient, given his criminal history. So the 60 days should be sufficient.
Okay. All right, Ms. Helen.
Yes, Judge, this is a non-negotiated plea. We are asking for time served for Mr. Willie Grace. He's 49 years old. I did hear the history about the 55 cycles, but Judge, at this time, we are asking that this be considered a time served plea because he has done 17 days in jail. And he wants to ask for this plea to be resolved, Judge, but he has no issues with the conditions. He understands the seriousness of these charges. He's also just heard the history from the state. So he understands there's no contact with Carol Kelly. He doesn't even know that individual, Judge. So there will be no contact at all. Has no issues with the 40 hours of community service. I just want a clarification. Is it an MHET? And if that's not needed, then it's a 8-week anger management?
I'll add both because it seems as if he needs an MHET and both because he has so many batteries. Yeah, we're gonna do both.
Well, Judge, in that case, again, when I spoke to Mr. Grace, he had no issues with doing that. He will do all conditions, Judge. And so we're just asking for it to be time served.
All right. And with the state's recommendation, he would serve approximately
15 additional jail days.
How old is Mr. Grace?
49, Judge.
50, man, 50 years old. 50.
Oh, you hit 50? Yes, Judge, 50 years old.
Oh, okay.
And I also have a stable address, Judge, where his father resides. He will be able to go to that address and receive help from his father.
Okay, I'm going to go ahead and render this a credit for time served with no additional jail time of 15 days and accept the plea with no additional service, but order the MHET and the 8-week anger management since the defendant doesn't have a problem with it. And Mr. Grace, you are to have no further contact with Carol Kelly and actually anyone else that you encounter on the street so that you stop these cases coming up of this battery or obstruction or anything. I'm concerned about your 55 cycles and the continuum of doing this. You also have no alcohol, drugs, or weapons while on probation, as well as 40 hours of community service that you're going to need to do as well. Are you clear about that? So I'm giving you a chance by rendering it a time served sentence, so you don't have to do the additional 15 days if you will stop doing things, okay? All right, don't want to see you again, okay?
Yes, ma'am.
Okay.
You go home today? I go home?
As soon as they clear you to get out, you should be. Maybe later, but yes.
Okay, thank you, Judge.
All right.
Wait.
Hold on. I've got to ask you the questions. Hold on a second. All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth, so help you under the penalty of perjury?
Yes, ma'am.
All right. And so I need to just ask you a few questions to make sure. Are you under the influence of any medication, drugs, or alcohol at this time? Are you satisfied with the services of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
And you're waiving and giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
And you're waiving and giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And also that you are prepared to agree to waive these rights, is that correct?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone told you that you are promised you anything to plead guilty?
Yeah.
All right. So do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And so to the charges of simple battery and obstruction of law enforcement officer, how do you plead?
Okay.
To the charge of simple battery and obstruction of a law enforcement officer, how do you plead?
I plead guilty.
Okay. And so I don't know if I heard, Ms. Helen, do you stipulate to venue identity in the factual basis?
Yes, Your Honor, I do.
Okay. Thank you. I don't know if we said it or not. But anyway, just to be on the safe side to make sure for the record. All right. So good luck to you, Mr. Grace. Okay.
Thank you.
All right. You're welcome.
Thank you, Judge.
All right. You're welcome.
All right. What's going to be the status for position number 25 and add-on 3?
Your Honor, we have an announcement for add-on 3. We will null pros that case.
Add-on 3 is
And that's
no
also
problem.
going to be for add-on 2 as well.
Add-on 2, no problem.
We don't need add-on 3 for court?
Sorry, Deputy.
Yeah, okay. I'll let him know that.
Yeah, add-on 2 and 3 are both no pros. So the only one we have left is add-on 4. And then what was the other one you asked about? 25?
Yeah.
For 25, I have hold for an announcement. Is that the PD's office? Is there an announcement on 25?
Yes, that's Mr. Finley's case, and I do believe he has an announcement. Hold on.
Okay, there we go. Mr. Finley, what's your announcement on position 25? Ross Farr, I think that is.
See. We're on position number 25, Your Honor.
Yes.
Yes, he's going to be a medical reset, Your Honor.
Okay.
What's the reset date?
And you want him reset till when?
Let's see if we could.
The next Thursday with the 3rd.
Okay, next Thursday, February 3rd. Okay.
Yes, Your Honor.
All right. Got that.
That's it for me then. I'm going to South
That's
Annex.
it for you? Okay. All right. I see South Annex. Thank you,
Yes.
Deputy.
Good morning, Judge Mincy. I
Good
have
morning.
two females here at the South Annex. I have position 18, Miss Mays.
All right. Are you Miss Crystal Mays? Can you hear me? Not sure if she can hear me, Deputy.
Yes, she can hear you.
Okay. All right. This is case number 20 CR 000-720E. And Ms. Mays, you're charged with 1 count of simple battery against police officer or detention officer, and also theft by shoplifting with the offense date of January 13, 2020. And this is going to be a negotiated plea, is that correct?
Yes, Your Honor. And just on behalf of Ms. May, she's really soft-spoken. So it was hard for me to even hear her in like almost the interview. So she's speaking if we could get closer to her.
Okay, gotcha. Yes, Ms. Mays, we're gonna need to hear you, okay? Okay, Nels, I think.
She's muted.
Uh-huh. The deputy walk out. I don't know if they allow them to. Mr. Jordan, can you oh, deputy, yeah, she's coming. Yes, unmute, thank you. All right, Miss Mays, we're gonna need to hear you. And so you may need to come a little closer, and I understand you may have a very soft voice, but I will need to hear your affirmative answers, okay? Okay, gotcha. All right. And so State, you may go ahead with the plea offer.
Yes, Your Honor, we're recommending 12 months to serve, 68 days. Credit for time served of 34 days. The balance is probated. A stay away from Shell gas station at 11114 Spring Street, Northwest Atlanta. 40 hours community service, a theft prevention class, no alcohol, drugs, or weapons, and both charges will run concurrent.
That's what I was explaining earlier. You know how you think you say something and then it's like, I didn't say that, right? It's been a long morning. Okay. All right. I am sorry, Ms. Mays. We're getting ready and your attorney is going to speak for you in a second, and then I'll ask you some questions. Is that your understanding, Ms. Helen, of the plea?
Yes, Your Honor, we do agree with the state's recommendation. We do stipulate to the factual basis, venue, and ID.
Great. All right. Ms. Mays, can you raise your right hand for me? All right. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth, so help you, under the penalty of perjury? Okay. Can you say yes for me?
Yes.
Okay. Because we've got a court reporter and she needs to be able to take down your answers, okay? All right. So let me say this to you. You know that you have a right to remain silent, but anything that you say about the facts or occurrences of your case can and will be held against you. So defer to your attorney, okay? Okay. Is that a yes? Okay. Are you under the influence of any medication, drugs, or alcohol at this time? Is that a no?
No.
Okay. Are you satisfied with the services and representation of your attorney?
Fine.
Okay. Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence? And that you're giving up or waiving the right to remain silent and not testify against yourself? And that you're waiving the right to trial by judge or jury, whichever you prefer? All right. And are you prepared to waive these rights today? Has anyone told you that you will receive a lesser sentence for pleading guilty? No? Can you say no for me?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you are currently on probation, your probation may be revoked because of your guilty plea here today? All right, and do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you? All right, and as to the charge of simple battery against a police officer or detention officer, how do you plead?
Guilty.
And as to the charge of theft by shoplifting, how do you plead?
Guilty.
Okay, all right. And so let me explain to you, the state offered 12 months to serve with 68 days of confinement, but they're giving you credit for time served for the 34 days, and the balance will be probated. They're also asking you, as a condition of accepting your guilty plea, that you will not go back to the Shell gas station at 114 Spring Street in Atlanta. Do you understand that? So you can't go back there, else you'll be arrested. 40 hours of community service, and the probation officer will give you that information so that you can conduct and do your community service, okay? And you also have to take a theft prevention class, and no drugs, alcohol, or weapons while you're on probation, except for any prescriptions prescribed by a doctor. And so with those charges, they're going to run concurrent together, okay?
I don't have nowhere to get there.
Oh, and I was just gonna let you know, Miss Mays, I've already talked to a social worker about transportation. Okay, she's gonna come down and talk to you about housing and transportation, okay?
Great. All right, so they're getting some assistance for you so that we won't see you again, okay? Which will be a good thing. All right. So I want to wish you good luck and they will get some assistance for you, okay? All right. All right, take care.
Thank you, Judge.
All right.
Thank you.
Next, Judge, I have position 4. She's an add-on Witherspoon.
Oh, the add-on, okay.
Come on, Witherspoon. This is Paula Witherspoon, an add-on on position 4.
Okay. This says hold for an announcement. Is this Ms. Helen or Mr. Finley? Mr. Finley?
This is Miss Helen's case, Your Honor.
Oh, wrong one. Well, it says on add-on.
Miss
before it's you.
Witherspoon, she's the 4th position on the add-on calendar.
Yeah, it says you, but I don't know, Mr. Finley, if you all switched or not.
And
I
if
have
not,
add-on.
Judge, can I get a break, or not even a breakout room, an opportunity to get on the phone with Miss Witherspoon?
Okay, you need to speak with her.
Mm-hmm.
Excuse me.
Yeah.
Who's trying to contact Miss Witherspoon?
I am, Deputy. What's a good number?
Okay,
Thank you,
just FYI, she might not talk. She is an MH.
Oh, okay. Well, Deputy, give me 1 second. Let me, we're gonna have to reset that, Judge.
Okay.
And I'm going to let my supervisor, Derek Howard, know about that case, but we will reset that to 2-3.
Okay. All right, reset to February 3rd. So that's it for the add-on calendar. All right, she's gonna be reset to February 3rd, Deputy.
Okay, thank you.
All right.
Thank you, Judge.
We're
All right, no
completed here
problem.
on South Annex. Can we be excused?
Yes, you may. Thank you.
Thank you. You're gonna be reset, Miss Witherspoon, okay?
Reset.
Yeah, you're gonna be reset. They're gonna reset you to February the 3rd
What?
for court.
What?
You're gonna come back to court on February the 3rd.
That's the phone.
All right, thank you.
And
All
Judge,
right.
we'll also request a social worker visit as well for
Yes,
position
make
4
that.
for Miss Witherspoon. Thank you, Judge.
No problem. So do we have announcements on these others, or do we still have to go back?
What's going on with position number 8? I have it now.
Yeah.
Complete.
Got several others here. Everybody says they're done, but we need to know what's going on with them.
Who has position number 8?
Position number 8. Is that you, Mr. Finley, or?
Nope, that's me, Judge.
Oh, okay.
And this will be a negotiated plea, Judge.
The jail is not, there's no one.
But there's no one, where's this,
Defendant.
I think all the courtrooms think they're done.
Mr. Daniel, he was on the email to pull. Let me check, Judge. Position 8, Mr. Daniel.
And there are a few other positions, Your Honor. That
Yeah, there
in
are several
waiver of
others, I know,
appearance.
but they did not relay messages to us today, it seems.
And Judge, there may, yeah, but I sent the email this morning. It's the same one I forwarded to you. Position
Right.
8 is a negotiated plea. I did request for that person to be here.
Right.
Can I just get a second to call
Yeah,
my
that's
supervisor
fine.
to see what's going on?
No problem. We'll just kind of hold for a second while she makes that call.
And position 33. Whose case is that?
33. Is that you, Mr. Finley?
No, that's, I think that's.
I don't know. Can we put in
No,
the,
Your Honor. Number 33, Miss Sonia Strong, that is Miss Helen as well.
That is mine, Judge, and give me 1 second just so I can figure out.
they've left all your people somewhere, so let's see what's going on there to find out. So which one, real quick before you go, we've got 8, 33, and what's the other one, Miss Champion? Or just those?
The rest of them.
Those are me.
The rest of them were released. I'm looking down the list. Okay, so just those two, 8 and 33.
Okay, Judge, I'll check on
Okay,
it.
okay. As they say, reading is fundamental. I'm gonna mute myself and then I'll check my calendar.
All right, Judge, we're ready on position 33. She was released last night.
Okay.
And we're
hold on 1 second. 33 released, okay.
Yes, Judge. And for position 8, we're still trying to contact the jail and see where position 8 is.
Okay. Now I'm
Mr.
just
Daniel.
updating on the others. Yeah, there's another one, Miss Helen, position 6.
Yes, Judge, that was a MH reset.
What's the reset date?
And what date would you like?
For February 3rd.
Okay. We'll do February 3rd on that.
And I do have the MH reset dates. Whenever you guys want to go over the calendar.
Okay, then you'll tell us. Gotcha.
You want to go
Okay.
ahead and go over the calendar while we-
You want to do that while we wait for 8? You think?
Yeah.
Sure.
Okay, okay.
Position number 1 was reset SAP 217. Position number 2, defendant was released, reset further notice. Position number 3, a waiver, reset further notice, jail jury. Position number 4, waiver, reset further notice, jail jury. Position number 5, defendant was released, reset further notice. Position number 6 is reset SAP 23 MH. Position number 7, reset SAP 23 medical. Position number 8, we're still holding for. Position number 9, reset SAP 23. Position number 10 was a waiver, reset further notice, jail jury. Position number 11 was a waiver, reset further notice, jail jury. Position number 12 was the plea. Position number 13, reset SAP 23 medical. Position number 14 was arraigned, reset further notice, jail jury. Position number 15 was a plea. Position number 16, reset SAP 210 MH. Position number 17, reset SAP 23MH. Position number 18 was a plea. Position number 19, reset SAP 23. Position number 20, reset SAP 210MH. Position number 21, reset SAP 23MH. Position 22, reset SAP 23MH. Position 23 was a plea. Position 24 was a bond hearing. The bond amount, total amount was 1,500 good bond, reset further notice. Position 25 was reset SAP 23 medical. Position 26 was a plea. Position 27, defendant was released, reset further notice. Position 28 was a plea. Position 29, reset SAP 217MH. Position 30 was a plea. Position 31, reset SAP 23MH. Position 32 was a plea. Position 33, reset further notice, defendant release. Position 34, reset SAP 224-2022. Position 35, reset further notice, jail jury, a waiver was filed.
Your Honor.
Hold on, 1 second.
Sorry. I did want to actually do, there was one thing I wanted correction. I wanted to do a jail jury bond hearing on 35.
Oh, you want to do a, oh, okay.
Is the defendant?
And that
Yeah,
was my
does he have
mistake.
the
Your Honor.
defendant?
Is the defendant?
No, that was a waiver of appearance. And I meant to do waiver of appearance.
Oh, and still do
here.
bond here. Gotcha.
Yes, ma'am.
Okay, all right.
So
We'll
we're
come
gonna
back
have a
to that
bond
one.
hearing on that.
Thank you, Your Honor.
36.
Position 36, reset further notice, defendant was released. Position 37 was a plea. Position 38, reset further notice, jail jury was a waiver file. Position 39 was a plea. Add-on 1 was arraigned, reset further notice, jail jury. Position 2 and 3 was null cross.
Ms. Champion, can you tell me your add-on one? What's the name you have?
That's Mr. Alex Griffin.
Okay, so yeah, my calendar is a little different. All right.
Okay,
Alex
position number 2 was Brandon Key, that was a null cross. Position number 3 was Malcolm Pamfield, that was a null cross. Position number 4 was Paula Witherspoon, that was reset SAP 23MH. And could you please send all null crosses to me so that the judge can sign, please? And we're still waiting on position number 8, and we can, if you want to go ahead, Mr. Phillips, with that bond hearing for position 35, we can.
Yes, Your Honor.
Okay.
Yes, Your Honor. Regarding Mr. Thomas, Mr. Thomas is 45 years old, born and raised in Atlanta. He has 5 kids of his own, 8 grandkids. All of his kids and his family live locally. He is very active in not only his kids' lives, but his grandkids' lives as well. He did achieve his GED, and leading up to his recent arrest was working at National Merchandising, where he held stable employment, and they do want him back once he is released as well. Your Honor, we are asking for a signature bond for Mr. Thomas. And if you're not inclined, then a good bond not exceeding $2,000 on Mr. Thomas's case.
All right. Ms. Anderson?
Your Honor, the state strongly disagrees. The state is seeking 12 months to serve with the Family Violence Intervention Program. The cause for that is because on 5/14/2018, several neighbors saw the defendant cuss out and then punch the victim, Terry Willingham, spelled Terri. Willingham is Willingham. They saw him punch her in the face twice on the street in front of the victim's minor daughter. The police were able to speak to Miss Willingham. She had a large laceration on her bottom lip. And although several people saw her get punched in the face, she says she got injured playing with a man inside the house and that her injury was from nothing important. We're very concerned about domestic abuse in this case, Your Honor. And this defendant has 38 Most of them are extensive drug history. He does have an open case, I think, a probation violation with an underlying charge of cocaine possession. And he does have 2 convictions that I see, a family battery conviction in 2003 and a weapon by felon conviction in 2003. And so for those reasons, Your Honor, we do not want to agree to a signature bond.
All right, anything else, Mr. Finley?
Yes, Your Honor. While I do understand Mr. Thomas's recent criminal history, he is presumed innocent in this case. And obviously bond is not meant to be punitive, but rather to ensure his return to court. So that is why we are still asking for a signature bond, but if not inclined, a $2,000 surety bond. Thank you, Judge.
All right, I'm going to give a surety bond of $2,500. No drugs, alcohol, or weapons while on bond. I'm going to order no further contact with Terry Willingham and a stay away from the address that I did not write down.
Your Honor, that address is 908 McDaniel Street.
Is that 2,500 for the battery or?
Oh, I'm sorry, 2,000 for the battery and 500 for the cruelty. That would be a total of 2,500. Is there anything else I need to take up on this matter?
No, Your Honor.
Okay.
Okay, Mr. Finley, if you can go ahead and prepare that bond order and send it over to me, please.
Yes, I will. Thank you, ma'am.
Thank you.
Okay.
We're still holding for position number 8.
I know. Is it Flavius Daniel?
Good morning, Judge. I do have an update on that.
Yes, sir.
I spoke with Sergeant Johnson, and he is on quarantine, which is why they didn't bring him. So
okay.
I guess we set him to 2-3, and hopefully we'll be able to get him in court then.
Okay. Gotcha. All right. That sounds good, Mr. Howard. Thank you so much.
No problem, Judge. She asked, were there any others that I needed to let her know about, or does that cover everybody?
I think we're covered. Are we covered, Ms.
ma'am.
Champion?
Yes, ma'am. That can help.
All right. Thank you. It's been a fun day.
Excuse me.
Judge, if I could, this is Albert Hopkins. How you doing today?
I am fine. How are you, Mr. Hopkins?
Great. I'm doing great. I just wanted to let you know that that notification on the null process on Pamphile and Key, that's going to be done. Those orders are going to be done by Natasha Crawford. They currently have hold still for felony. That's why we're not sending those null process directly over to you or the jail. Those are going to just be filed down normally. But I just wanted to inform you in case there was any questions, and so the PD's office knew that as well.
And that was my understanding, Judge. I spoke with Ms. Crawford. So
great. Okay, great. All right. Thank you for your patience, everyone.
Excuse me.
Judge, you had the patience of Joe.
Hi. Hey, Susan.
I'm glad I brought my lunch today because I need food. Okay? Yes, Ms. Greenhouse, since
yes,
you've been involved today.
I thank you. I just wanted to mention, as the hearing went on, I did remember there was one criminal case where a judge did declare indigency for the defendant who had requested a trial transcript. And so I did produce a trial transcript for that defendant based on that.
You are telling me, Ms. Champion, do we have some type of form that I can declare him indigent? I really don't know. I didn't hear evidence of that. I'm going to probably make him go through the proper process. I'm afraid to do that and then find out he won the lottery yesterday and he's a millionaire, you know? So I better err on the side of caution with the way this day has gone. He'll figure it out, I'm sure, but thank you for that information that I can. I guess if I would have continued to entertain him a little longer, I could have found that out, but who knows? I think he was just having fun with me. Right, Mr. Howard? He was just having fun.
Yes, he was having fun.
But yeah, but thank you for that, Ms. Greenhouse. I appreciate it.
You're
All right.
welcome.
All right, everyone have a good one. I'm gonna be doing C, so
Okay.
filling in for law today. Okay.
Thank you, Judge.
All right, thank you. See y'all later. All right,
Appreciate it.
bye-bye. Bye-bye.